Welcome back to Insight. If you're an employee or an employer, get ready for some changes in the labor laws. Thomas Kimbrough from Barrett McNagny has some information you should know. And Thomas, what legal changes are ahead here in 2017?
Well, probably the most significant event recently is the injunction that was issued by the Texas court, United States District Court in Texas, where the delayed or stopped the implementation of the Department of Labor DOL rules.
Yeah, it's thrown things into chaos, hasn't it?
Well, essentially, yes, because employers have been planning to implement these rules for about the last 6 months. And with the injunction, the law was to take effect December 1st, and the employers that had, some of them implemented the laws, some of them had gotten ready to implement the new laws, and now they have been enjoined, and so employers are sort of in limbo as to what to do.
Should they go ahead and act as if the injunction hadn't taken place? Is that safest, or is it just a wait and see? Or
well, that's a good question, because we don't really know what is going to happen at this point. It is being appealed to the Fifth Circuit Court of Appeals at this point, so it could be overturned. And if it is overturned, it could be retroactive to December 1st at this point in time. We also don't know if the change in administration, whether the Department of Labor is even going to go ahead and implement these new rules, because they were controversial at the time. So we really don't know what the Obama administration is going to do with these new rules and whether they're ever going to be implemented. So in the meantime, employers are truly left in limbo. And to answer your question, employers are doing both. Some employers are going ahead and implementing the rules that they have already put in place. Others have just treated the rule or the new regulations as if they are not in effect, and truly they aren't in effect.
It's a crazy time. All right, talk to me though in general about, like technically, you can work for somebody but still not be an employee. Am I getting that right? There's another phrase for that.
Well, I think you're probably referring to the whole dilemma right now of independent contractor status and joint employer status. And one of the other developments over the last couple of years has been the Department of Labor's interpretation of those rules. And for example, if you have truck drivers that work for companies, a lot of them are classified as independent contractors. You have temporary staffing agencies that supply employees on a temporary basis to employers. The whole question of who's the actual employer. And from an IRS standpoint, it's important, and also from just a litigation and liability standpoint, it's important. And the Department of Labor rules that have been implemented over the last couple of years, or at least been interpreted, has put a much stricter standard on both sets of rules, and essentially are now ruling that if the employer has the potential of exercising control over those individuals, independent contractors or staffing employees, they will be deemed to be employees of the corporation. So either they're no longer independent contractors, they're actual employee, or there'll be a joint employer with the staffing agency.
See, this goes back to, I think, when I was 15 as a paper boy for the old Marion Chronicle Tribune.
Exactly.
It was like, you're an independent contractor. I'm like, wait, but you can tell me everything I have to do. You get mad if I don't get the paper there at 6 o'clock.
It's a great example, because paper carriers traditionally, and still by most newspapers today, still treat their carriers as independent contractors, even though they might be working solely for that one paper. But the whole idea of an independent contractor is that you can work for various different employers, and you do have the right to control what you do, when you do it. You're using your own equipment. You can even hire your own employees to get the job done. Those rules have become blurred, especially if you start working, say, as a truck driver for one company. You're a staffing agency assigned to one company. And that's where the IRS and the Department of Labor has stepped in and really strictly interpreted those rules and said, no, we're going to deem you to be employees of those corporations.
I have to think that there's some long hours ahead for you and all the things going on here with all the changes in the labor law. If you want to make sure that you're up to date as an employee or an employer, head over to barrettlaw.com and find out more, or you can give them a call at 423-9551. We will be right back on Insight.